Everyone, please be seated. It just feels different. You can tell it's dark outside. This is unusual for us, like night court. We appreciate everybody, whatever it was you did today, going home, kind of unwinding, and then getting your good clothes back on and heading out the door and back to the judicial branch. So we appreciate very much all of you who are here tonight to hear an oral argument. It's also my understanding we have the Dowling High School mock trial here. Raise your hand if you're Dowling mock trial. Raise it with pride. I heard there was like 15 of you. Come on. All right, and your coach is Frank Steinbach, correct? Thank you for being here. And my colleagues know what's going to be next. But I think it's awesome that you're here. It's an experience. Every one of us has a different track, path, how we got here. But the common denominator with each and every one of us is we, of course, have a high school diploma. I graduated from Harlan High School in 1980, the same day Mount St. Helens erupted. We are the Harlan Cyclones. And I will go in order of seniority, right to left, and let you hear where the other judges graduated from.
Tom Waterman. I went to Bettendorf High School, class of 77. Go Bulldogs.
I'm an Iowan by choice. I went to Lexington High School in Lexington, Massachusetts. Lexington is where the militia gathered to confront the British on April 19th, 1775. So, of course, we were the Minutemen.
Christopher McDonald. I went to Des Moines Lincoln High School, home of the Rail Splitters. So I know you Dowling guys pretty well.
Dana Oxley. I graduated from what was Greenfield High School. It's now Nottoway Valley. It was Greenfield Tigers. I think it's Nottoway Valley Wolverines now.
I'm Matt McDermott. I graduated from Kemper Catholic in Carroll.
Go.
The Fighting Knights.
I'm David May. I am also an Iowan by choice. I went to Kirksville High School in Kirksville, Missouri, graduated in 1989. And like a lot of Missouri schools, we chose the Tigers.
Not everybody listens to me. Gosh. I'm going to ask the lawyers. It's my understanding Mr. Ogden is going to be representing the appellant and Mr. Taylor for Appellee. And when you start, tell us where you went to high school. And the appellant may begin. Mr. Ogden. By the way, this is the case of State of Iowa versus Starr.
My name is Thomas Ogden. I am a 2006 graduate of West Des Moines Valley High School. Go Tigers. May it please the court. An attempt to resolve an ongoing threat to public safety is a necessary delay before permitting a phone call to a family member under Iowa Code Section 80420. This court's precedents dictate that Section 80420 is to be applied in a pragmatic fashion, balancing the rights of the arrestee against legitimate law enforcement interests and public safety. By its very terms, the statute, specifically the phrase, "without unnecessary delay," contemplates such a thing as a necessary delay. This court has also recognized that firearms abandoned in a residential area represent a genuine threat to public safety. In this case, you had a stabbing and the defendant followed his victim into her car to a gas station, was trying to injure her, I think hitting her with a brick. She was attempting to escape. She got into the gas station and he fled on foot. Only a few blocks away, he broke into a house that was occupied and he grabbed a shotgun, he grabbed an AR-15 rifle, and he grabbed several clips of ammunition and fled again.
So far, how much time transpired from what you started, from at the convenience store to just now? How much time?
About 15 minutes. He was considered on the loose at that point. This was early in the morning, shortly before 8 a.m. The school's There are several schools in this residential area.
Longest delay that's been allowed before there's been a finding of a violation of 80420?
That's a good question, and it's difficult to answer because, well, for two reasons. One is, as I'm sure you know, the vast majority of this court's precedents on 80420 involve investigations of OWIs, which have their own time limit. And then on top of that, many of the cases don't go into detail about exactly how much time elapsed between the invocation and the actual offer of the phone call.
Right, is the need to find the firearms in the community. Is that correct? Let's assume that Mr. Starr never revealed the location of the firearms, but was still talking. Would it be permissible then for the police to not allow him to make that phone call until he reveals the location of the firearms?
I think that if he had given some indication that he was unwilling or unable to reveal the location, you might end up in a situation where the law enforcement can see this is going nowhere. We're not going to be able to, he's not going to divulge it, or he can't divulge it. Go ahead and offer the call at that point.
I mean, if your position is that the public safety exception justifies denying the statutory right for any length of time, it seems like until he gives them the information that they want, they can continue to go ahead and keep denying the right. I mean, what's the cutoff in your mind of how long is too long?
Respectfully, Your Honor, I think that's a little bit broader than our position. We're talking here about a delay, and the delay is justified by the officers making an effort to locate the firearms. I think that if it became clear to them that that effort was not going to bear fruit, then the statute would direct them to permit the phone call.
I think this record shows that he was brought into custody about 36 hours later. So the events that you were just talking about happened at 8 a.m. The next day at about 3:30, 4:30, something like that, he gets brought in. Let's say that he doesn't get brought in until 7 days later. Can they still hold on to him without letting him have his phone call?
I think that you're probably talking about a little bit of a continuum there in terms of whether the officers have a reasonable belief that there is a threat to public safety that they need to address. And I think that in this case, the facts justified the officers' belief that those guns had been abandoned or stashed in a residential area. And so whether it's 1 day or even a few days later, I think that they are justified in at least taking a crack at trying to find them before a child does.
Almost every case. I mean, how often do we really have the gun? You have a shooting victim, and maybe you have a pretty good idea who the defendant was, but there's no weapon on him. Wouldn't that be like almost every case? Okay, until you tell us where the weapon is, we're not going to let you call your lawyer. Where's that line that we draw? How is this different than other cases where they don't know where the weapon is?
This case is, first of all, it's not a shooting. It's not a gun that he... So there was a knife involved, but the issue with this case is that these guns were stolen as part of a kind of almost like a panic on behalf of the defendant. It's not as if he possessed the firearms and, in a situation, in your typical shooting, law enforcement probably doesn't have reason to believe that the gun has been abandoned in an area where it represents a threat to public safety. If you do have that situation, such as hot pursuit and the gun is tossed off, in that case, I think you do have that threat, and you can see that in cases like Quarles and In re JDF. But in your typical shooting case...
Situation, the officers are asking them there on the scene. Here they found him near Unity Point. They took him to the police station, and then they were questioning him. They could have taken him back to the residential area and said, we need to find these guns. This is really urgent. But they didn't do that. So how how do we determine when there's the type of delay that would require not giving the phone call under 80420, which doesn't even have to happen until they get to the police station?
So you bring up an interesting point, which is that he was brought to the place of detention before he was interviewed about this incident. Why they didn't question him when they arrested him, I don't know. It's possible that the officers who picked him up on the warrant didn't have all the information. But it's an interesting point to bring up, because if they had questioned him, Mirandized him and questioned him, say, just in a squad car, 80420 wouldn't have even attached, even if he had requested to call his dad.
I mean, how does that cut? It seems to me just sort of my general sense of the timeline, correct me if I'm wrong, is they arrest him, then he's sitting in custody for 45 minutes or so, cooling his heels, while they go find a detective, somebody who's sort of a professional investigator. Then the detective immediately Mirandizes him, so it wasn't enough of a public safety threat to need to avoid Mirandizing him. And then it's another hour or so before the detective brings up the subject of the guns. So doesn't that kind of vitiate the general position of the state that this was such an emergency?
I think there's a distinction between the kind of emergency that results in the application of the public safety exception for Miranda and the type of public safety threat that we're talking about that may necessitate a delay in a phone call under 80420. Because in the former case, you're talking about discarding the entire prophylactic measure that protects the right against self-incrimination. We don't have that here. What we're talking about here is essentially a question of priorities. And, you know.
Same. If you don't honor the rights, and we conclude, or the trial judge in this case concludes that the particular right wasn't honored, you suppress the answers to questioning that occurred after that. So, I mean, it strikes me hard to accept that it was such an emergency that you couldn't honor the 80420 rights, but it wasn't enough of an emergency not to honor the Miranda rights. It's the same issue. It's what do you have to do before you can question the suspect, and isn't it? And it's the same concern that things will get delayed and the suspect will call a lawyer and clam up.
Well, respectfully, Your Honor, I think that it's a little bit of a different consideration. In 80420, what you're talking about is it doesn't have to be an emergency situation. It just has to be a necessary delay under the statute. So you could see, you know, the administrative tasks or the security measures that go along with booking, those are certainly not emergencies. And, you know, if you wanted to quibble, I suppose you could ask whether they're really even strictly necessary. But that's where you get into this pragmatic approach that this court has directed 80420 to be applied with, where, as I said, what you're talking about with 80420 is essentially priorities. And so if you have something that you need to get done that's a higher priority than permitting the phone call under 80420, you've got a necessary delay.
A question then. So your thought process is, or your position is, that the fact that there are a couple of guns somewhere, even though the police have searched ardently to find them, they're somewhere, and that's a big enough danger to prevent a phone call a day later, right? So that's enough. Okay, what if there was a missing person? I mean, would you be able to hold out forever? Because, you know, if they make the phone call, they might stop talking. I mean, to me, if this person had been, you know, a week, a month, I mean, it does raise the question for me.
Once again, I think that goes back to the question of whether the officers have reason to believe that that resolution of this issue is necessary before they get to that phone call. And in this case, where you have firearms taken from a house, This isn't a situation where you expect the person to, he's not taking them in order to like pawn them or, in fact.
How do you know that? I mean, so one of the arguments that it strikes me that the state is making here is that it's not just that these guns are somewhere, but that they're stashed somewhere publicly where a child is going to find them or something like that. What evidence is there of that these were stashed publicly or that there was some public danger at that time, 36 hours later?
So the defendant had attacked this woman. He was, she gets into the gas station and he flees, right? He's on camera. The officers are aware of this individual. They have good reason to believe that he's probably high on methamphetamine, and he flees into this neighborhood. The house that he burglarized the guns from is a couple of blocks basically across the street from this gas station, and then his victim's house is just a couple of blocks further down from that. So I think the officers had reason to believe that, he's in a panic. He goes into this house, he grabs a couple of guns, maybe he takes them over to her house, finding her not there. She was at Unity Point. He ditches them and takes off.
How do we assume that he just ditches them? I mean, where does that come from, that these are hidden somewhere public, that there's this big urgency that we have to search parks, or we have to talk to him further? Why do we think that?
It's impossible to know exactly what he did with them from the officer's perspective because, of course, they weren't there. But I think it's reasonable to assume that he's not walking down the streets of Sioux City with 2 long guns and 4 clips of ammunition.
Allows the officer to listen in to the phone call, right? So that reduces the risk that he's going to alert some Confederate to hide the evidence. Shouldn't we factor that in on whether it was necessary to delay a phone call to his father to secure legal representation?
Once again, I don't think that the delay that we're talking about is not necessarily, as I said, the best way I can put it is that it's a matter of priorities, right? I mean, you could parse all sorts of delays that have been recognized as necessary, like the administrative, booking tasks, and say, well, that took 10 minutes. Did it really need to take 10 minutes? Could you have gotten it done in 8? Does that make that extra 2 minutes unnecessary? And I think that using the pragmatic approach that this court has counseled, it's unnecessary to do that. What you have to do is you say, is this a legitimate exercise, and was it?
What you're saying, kind of as I look at the fair reading of the statute, unnecessary delay, it just seems to me it's kind of a carve out to avoid the kinds of problems you're talking about, which is we're not going to find violations of the statute for booking and kind of regular processing. But I don't know that that implies that there's just some sort of exception to the statute that the officers can invoke, as you put it, because they have other priorities beyond processing the defendant. I mean, to me, the things you're talking about seem like the safe harbor to make sure we don't have a bunch of ticky-tack technical violations, not an escape hatch that just lets the officers decide when they're going to grant the statutory right. Why isn't that a fair reading of unnecessary delay?
Has expired. May I briefly answer the question? So I understand your question, and it's a good one. And I think that, first of all, I wouldn't describe it as an exception. 80420 directs officer conduct, and what it's telling them to do, that they are not allowed to do, is to what they have to do is to permit this call without unnecessary delay. And so, they have all sorts of things that that could be, and I don't think that the statute is capable of listing out all of those. And I would just point out that in other states, there's about 15 others that have similar statutes, and several of those, most of them use language like ours, either unnecessary delay, as soon as practicable, as soon as possible. But several of them actually give a time frame, and most of them look at 1 to 3 hours as basically a per se rule of reasonableness. So we're certainly within that here, and I think that for that reason, it was not unnecessary. Thank you.
Mr. Taylor.
Counsel. May it please the court, and I attended high school in Kelmer, Iowa, at South Winneshiek High School in the middle of nowhere, northeast Iowa. Go Warriors. So this case is about police misconduct, period. This is not a case about the safety and application of the public safety exception. And we know this based on the detective's statements. His response to Mr. Starr and when he invoked his right to 804.20, Detective Grimsley told him, well, that's the thing. That wouldn't happen today. That right there is the violation itself. It indicates to Mr. Starr, though we're sitting at a police station on a Tuesday at about 4 o'clock in the afternoon, that he is not going to have access to the outside world to be able to talk to counsel, to talk to his father. And that's the violation.
I want to make sure I understand. So there's the convenience store stabbing situation, whatever it was, the domestic situation that kind of was the spark that started things, right? How much time passed before there was the burglary?
The thing about the record is we don't really have concrete information that ties Mr. Starr to this burglary besides.
Like, that's important information. It was reasonable to assume it was him. How much time till the burglary at issue, whether he did it or not?
In a matter of a half hour.
How much time before he was apprehended?
36 hours.
Then, once he was apprehended, how much time till he said, I want to talk to somebody?
I'm talking about less than an hour when that occurred.
Question before he was allowed to make that call.
And we have a testimony from the detective about he offered this phone call. I don't think there's anything in the record that really establishes when that was done, because that's not part of any of the exhibits. That wasn't indicated in the police reports, the minutes of testimony. So,
make the call at that point. How much time are we talking about from the time of the burglary to when he wanted to make that call? How many hours was that?
Burglary to the phone call, I think we're talking 37 hours, 38 hours. And to go back to this public safety exception, in terms of how it can apply in a case like this, 804.20, there's not really a situation or a circumstance where 804.20 is really going to be an issue as it relates to the public safety exception as contemplated by Quarles, as contemplated by JDF. In those cases, it's very clear that we have a very narrow scope, and that's something that this court has held, that the scope is very narrow. We're talking about a very specific fact situation where we have a suspect who was witness with the firearm, who then leads law enforcement on a pursuit that lasts a matter of minutes, and then that suspect is apprehended without a firearm, leading to strong circumstantial evidence that that firearm was discarded haphazardly, and where that firearm might be just laying out in public view. Now, in this case, we have 36 hours that have passed from the time that this burglary occurred to the time that Mr. Starr is apprehended and in custody. And as the detective testified in his own words, his theory was these firearms were stashed away. He wasn't even of the belief that these firearms were left out in public view for a child or some other citizen to pick them up.
Is your argument here that on the facts, there was no public safety rationale, or is it that the statute doesn't even allow for a public safety exception, even if there were one on these facts?
Justice Mansfield, the answer is both. I think, obviously, to even get to the question about whether the public safety exception should apply to 804.20, you have to look at the facts, but I think clearly the facts don't even apply in this case because, again, looking at our prior case law, especially JDF, very narrow circumstance what we're talking about. And we have to have that strong circumstantial evidence, as I was discussing with the Chief Justice. That doesn't exist in this case.
Question then, what is the best response to the state's position that textually the word unnecessary implies that there are some necessary delays that the police can take into consideration before allowing the phone call?
The issue with that, even getting to that point, is what factual circumstance where the emergency, the situation where we would get to a point where someone's already in custody in an interrogation room to be about to be questioned, when would that apply with 804.20 if we're talking about the factual circumstances that arise with JDF? And so that's the issue, is that there wouldn't be really a necessary situation for this exception to apply to 804.20.
Of one, I mean, one of the guns was an AR-15, right? And so, I mean, not necessarily these facts, but certainly if somebody is arrested and then there's information that that individual did leave a firearm like that near a school, abandoned on the ground somewhere, you would want to, wouldn't that seem to be, maybe you could delay in either in administering the Miranda warnings and or in honoring the 804.20 rights?
Mansfield, what we need out of that situation is some objective facts. And I think that's what JDF and Quarles talks about, is objective facts where we have witnesses and we have information that's been provided to law enforcement so they can conclude based upon the circumstantial evidence.
Justice May's earlier hypothetical of, let's assume we have a missing person and you have somebody in custody, and we would conclude that is a sufficient public safety or emergency situation. So as a textual matter, kind of statutory interpretation question, what is your response to the state's position that unnecessary implies there are some necessary delays that the police can invoke?
We're talking about, and I think that hypothetical sounds awfully like Dirty Harry and that child being buried out there with lack of oxygen. In that situation, unfortunately, what we're talking about at that point is just opening up the floodgates to allow for basically all these rights to be eroded, because if that situation arises, then what would we do with Miranda? What would we do with an invocation of someone trying to remain silent or ask for an attorney in that point? If they're in custody and we're talking about a missing person.
Well, I understand that, and I understand you think it would be bad. I'm asking you a textual question. The statute uses the word unnecessary. The state says that implies there are circumstances where delay is necessary. What is the response to the textualist argument?
I would take what you, Justice Mansfield, were asking about earlier is, I think that language was really just trying to cover the basis to allow for just the process of booking someone into the jail and allowing for those procedural aspects of arrest, detention, especially an investigation where you have to have them fingerprinted, identified, and processed for being locked up at the local jail. And so I don't believe that plain language allows for this type of exception.
Another question. In my review of the record, I thought I did see on one of the DVDs later on where he is afforded that right to call, your client is afforded that right to call his father, and it does happen later on, and he doesn't seem to know the number. What do we make of that?
Point, and I think the problem with relying on allowing for this to be delayed is the whole purpose that Mr. Starr, and I think this is very clear from the evidence, is that he was struggling with this decision whether he should talk to law enforcement. I think that's abundantly clear, regardless of whether there's a Miranda violation or not, or 804.20 violation. And at that point, he wants to help make this decision about whether he should talk to law enforcement. And when the detective basically says, nope, not gonna happen, then the violation's already happened.
I think I read that a little differently. So it says, defendant says, then why don't I just call my father and have him get a lawyer and we can sign this paper and we can talk. And then the detective says, well, that's the thing. That wouldn't happen today. All evidence that was obtained after this, sorry, that wouldn't happen today. So that's it. I get what, as I read that, he is saying, after I talk to my lawyer, then we can talk. And the detective is saying, yeah, that's not going to happen today because he's not going to get a chance to actually talk to his lawyer, and then yet that night still talk. I don't read him, I guess, as saying that it's never going to happen.
Well, I think regardless, 80420 contemplates the idea that a lawyer would show up to a police station and allow for that in-person visit. And there was this whole discussion that we had on the record about what was reasonable at that point, which would be 4 o'clock on a Tuesday, about having a lawyer show up to the police station. And the bottom line is that whether the detective was talking about a lawyer showing up for that in-person consultation, whether it was just denying the ability to make the phone call at all, either one of those result in 80420 violation, because the in-person consultation with counsel is contemplated by the statute. It is something allowed specifically by that statute. So that would be still a violation if the detective was denying the ability for an in-person consultation.
No matter what's left of the state's case if we affirm the suppression ruling.
The statements made by Mr. Starr in those exhibits really relates to the burglary charges. Obviously, the willful injury has a different set of facts that could allow that charge to move forward, but as it relates to the burglary charge and as it's relevant to this conversation, there really isn't nothing else to tie Mr. Starr to those firearms, but for the fact that it happened around the same time and he was in the vicinity.
Clear that a violation of 80420 requires suppression of any evidence drawn from the statements that occur after the violation?
Would be abundantly clear, and even without the precedent, I think this is the type of situation where 80420 is incredibly important because, as I discussed earlier, we're talking about an individual that is seeking to have counsel talk, or his father, in order to get advice about what he should do about signing this waiver of Miranda.
The statute, that statutory right, if the state won this appeal.
That simple misdemeanor, which I don't know how often that's ever been prosecuted. I'd be surprised to learn if that's ever been prosecuted in the state of Iowa, but Iowa clearly has a long history with the exclusionary rule. I mean, this is precedent that's been on the books since State v. Veeder back in the 70s, and Iowa has long made its own path when it comes to the exclusionary rule, and so I think it's of the utmost importance that this exclusionary rule still applies to this statute, especially for something that is so important with someone's ability to communicate with the outside world. And something the state referenced in terms of this is, when we're talking about this invocation, I think there should be a clear distinction made between the fact that this is invoking a right versus Quarles and JDF, which is just for Miranda, the advisement of rights. So obviously, Iowa has held that this is a bridge too far. Issue was discussed in State v. Lowe, where the court contemplated expanding JDF to an invocation of the right of counsel and said, we're not going to decide that issue today, but clearly recognize that is a different concept when we're talking about invoking a right versus just being advised of Miranda.
All the cases that were cited by the state, what is the outside period of time compared to this case of 36, 37 hours?
I can't think of most of the case law that that is discussed when it comes to 80420 involves OWIs. There are a few cases that discuss 80420 in the context of outside OWIs, but
Any more than this time?
no. Nothing that's even close to the amount of time that passed.
To the public safety and Miranda violations.
Each one In those cases, we're talking about a matter of minutes after the suspect is detained by law enforcement. Again, a very specific fact pattern of someone that is fleeing from law enforcement, detained, law enforcement sees that the firearm that was observed earlier is no longer there. They ask where the gun is. That's the exception. Now, applying it to an investigation or applying it to obviously when we're talking about an interrogation, where someone's sitting in that cold police room, light shining on them, and then they get denied access to make that phone call, obviously quite the difference. And
But the state could have avoided this whole problem, right, if they just hadn't taken them to the place of detention in the first place.
if I may answer the question. Thank you. I would not even concede that point because at the time that Mr. Starr is detained and arrested outside the hospital, we're still talking about the 36 hours that have passed. That is still not falling within that exception of JDF, where it is an immediate pursuit, which is a matter of minutes. And so with that, thank you, Justices of the Supreme Court. I ask you to uphold the district court's decision.
Mr. Ogden, you may respond.
I want to address a couple of points. First of all, I'm going to disagree with Mr. Taylor a little bit on the nature of this interview. I think that the interview, it's important to note that this interview itself was entirely voluntary. I will admit that the defendant was upset, certainly, appeared to be somewhat confused at various points, but any consternation that he expressed was not really about talking to the detective. It was about signing the form, which he didn't do, and he didn't need to do. And I also want to point out, I think it's important to remember that 80420 is not a prophylactic that protects the right against self-incrimination. We already have that. That's Miranda. What 80420 is designed to do is to prevent the incommunicado incarceration that the courts have always been concerned with in this country, and to allow for a consultation, I think really specifically to assist with the decision whether to refuse chemical testing under the implied consent regime.
Excuse me, go ahead. But the statute doesn't limit 80420 to OWIs, correct? And so we'd be just creating a new limitation on the statute that the legislature didn't create if we followed your path.
Respectfully, Justice May, I'm not asking you to limit it to OWIs. What I'm asking you to do is to apply it in that pragmatic manner that I talked about, okay? So when you're not talking about OWIs, what you're really talking about with 80420 is this idea of incommunicado incarceration. And this court addressed that in some detail in the Davis case. The statute was passed in 1959. There were no cell phones. If you're picked up by an officer.
It's kind of an exemplar of the incommunicado interrogation. He says, I want to call my dad, and the officer says, well, that's not going to happen today. That seems exactly what the statute is targeting, is holding somebody in a police station when he's trying to make a phone call, and the police officer says no.
That first, I think the officer's testimony is that what he meant by that comment is exactly what Justice McDermott said. He's not going to be able to get a lawyer to consult with him and still have this conversation.
We're all lawyers. I mean, people work after 4 o'clock. It's not hard to find a lawyer at 4.
I do think that if you calculate the time, it was probably closer to 5, but I will admit that, you know, he may have been wrong about that. But I think that that was what he intended to communicate. Second of all, you know, as I said, if you look around at other states that have this these right to communicate statutes, the ones that specify a time frame are generally looking at like 1 to 3 hours. They'll say something like, as soon as practicable, but no longer than 1 hour or no longer than 3 hours. And in this case, from the time when the actual interview started, he asks, or he mentions calling his dad about 10 minutes in, and then, you know, there's an interview, they go to retrieve the guns, they come back, you know, he is offered an opportunity to make the call. He doesn't remember his dad's number. He declines to make the call, but the total time that he was actually interviewed by the officer is about an hour and 45 minutes, give or take.
Let's assume that we found that there were circumstances that would justify delay. The cases you cite, Quarles, Orozco, which is a case that Quarles distinguishes, I haven't seen a case that really applied this public safety exception outside either something immediate, as Mr. Taylor indicated, maybe 4 hours where a weapon's missing at the most. What's your best case for applying this exception 36 hours after a firearm goes missing?
Well, you know, to be candid, I'll concede that there are not a lot of good cases on what the state is asking this court to do here, because the precedents on 80420 just don't really fit well with the circumstances of this case.
And a public safety exception case. Like, as I read Quarles, they distinguish a case called Orozco, and the facts of Orozco is a gun's missing for 4 hours, and in that case, the court says the public safety exception is passed at that point in time, and that's 4 hours of delay. Here we have 36 hours. So what is your best case that gets you close to 36 hours?
Has expired, if I may briefly respond. Well, I don't think any of those Miranda cases, I'm not looking for a case that says you get such and such an amount of time, because I don't think we need that under 80420. Like I said, we're not asserting that this is an emergency situation. We're asserting that this is a higher priority in terms of law enforcement procedure once they get him into the place of detention. And so, you know, the 36 hours, I mean, you just have to look at whether it's reasonable for them to believe that they could get the guns, not whether, you know, when the clock starts or how much time gets to tick off before they have to give them the phone. Thank you.
Thank you. The case of State versus Starr is hereby submitted.